Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets, such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho. I'm an attorney here in the Intellectual Property Group here at Williams Mullen, and I will be joined by my colleague, Elizabeth Davenport, a paralegal in our IP practice group. We will be discussing Paralegal Insights, a collaborative trademark practice. Specifically, as we face the year-end, trademark budget considerations, as well as new developments before the United States Patent and Trademark Office, or the office as we call it. Elizabeth, how are you doing today?
I'm good. Thank you, Janet.
Well, I think these are really important topics, so why don't you go ahead and just kick it off?
Okay. The USPTO is implementing new rule changes as part of the 2020 Modernization Act. This is the USPTO's plan to clean up the registry and make the registration process more efficient. Some examples of the changes are, on December 3rd, 2022, the timeline to file a response to an office action will be reduced from 6 months to 3 months. However, if that 3-month deadline, you are not ready to file the response, we can file a request for a one-time extension at a cost of $125. This new change does not affect response timelines for extension applications to the U.S. based on Madrid. Also, this change is not for post-registration office actions as yet. That is slated for October 7th of next year. The office is also implementing easier ex parte expungement and re-examination processes to, again, clear the registry. A couple ways to make it so that you know what to budget for the next year and to make sure that you are not audited for not using your mark on goods or services is to review your website for updated versions of registered marks or new marks that are being used and are not subject of an application or registration. Also, when maintenance filings come around, remove any goods or services that you are no longer using to avoid, again, the USPTO audits and possibly decrease government filing fees. For also cost and budgetary strategies, we can take advantage of filing foreign applications within the 6-month filing from a U.S. application claiming priority. And there are different ways to approach foreign jurisdictions filing in individual and national applications, or in some cases, taking advantage of a single registration process, which includes specific jurisdictions such as EU IPO filings or WIPO filings. We can also take advantage of filing U.S. applications as TEAS Plus applications, which includes using the USPTO's already accepted descriptions of goods and services and provide other relevant information when filing the applications, which saves government filing fees, which are currently $250 per class to $350 per class. If you file a TEAS Plus, it's $250. If you file a standard, it's $350. And this might not be too concerning if it's just a one-class application, but if you're filing a multi-class applications, you can do some savings there. You can provide notice. Other ways to help with reducing costs is to have an idea of what your upcoming deadlines are, to have portfolio reports and estimates of upcoming filings for U.S. and for foreign countries.
And I think, Elizabeth, that's a very important point. Your last point about status reports or knowing what's coming up. We have a fair number of clients who want to be able to do some long-term planning, at least in terms of their trademark budget, and they certainly don't want any surprises along the way, as best they can control that. So for those who are working with attorneys or those helping you with your trademark portfolio, I think it's reasonable to inquire, what are my deadlines coming up in the next year or the next 12 months or whatever timeline is operative for you, and asking, what are my estimates of cost? We also can send monthly or on whatever timeline you request or need it, status reports of, what is the status of the marks that we're overseeing for you? What's the next deadline? What needs to happen? So I think in all of this, as Elizabeth mentioned, it's really important to have information by your side. I think the information helps you make really strategic decisions as to when you will act, for what mark you will act for, and what is the best way to manage costs. So I think your suggestions, Elizabeth, are really helpful.
Thank you.
One thing I would also add to the issues that Elizabeth raised before the office, before the USPTO, is also to think about what are some ways that you can take a look at your own marketplace to ensure that no one is infringing your mark, because infringement of your mark is a cost as well. Certainly the cost of pursuing action against a third party, but also it could tarnish or dilute your brand. So I would also take this opportunity in terms of your year-end planning or your look ahead to see what your marketplace or what your landscape looks like. I would also encourage everyone to make sure that you as a brand holder are not in turn infringing someone else's trademark. So if you are a licensee of someone else's mark, just making sure that you are using a mark within the bounds of the license or the license is not expired. And also the same with outbound licenses that you've granted, which is part of the enforcement work I just mentioned, but also making sure that your personnel and employees or teammates, vendors, contractors are knowledgeable about how best to use other parties' intellectual property and trademarks, meaning making sure that those within your company are not infringing someone else's trademarks, because that can be a cost too, just as you are investing in enforcement actions against others. You may be the recipient of, say, a cease and desist letter, which may require you to pay a fee or defend in a proceeding. So I think in addition to everything, thinking about budgets and rules changes, also taking an internal and external look at the marketplace and within your own teams to make sure that your brand is properly protected and that your personnel know the best practices in terms of engaging with third-party intellectual property as well. So, Elizabeth, thank you so much for sharing your information. It was really, really helpful, and I hope that it was helpful for those out there considering their trademark year end. And that will wrap up our discussion on a collaborative trademark practice. I'd like to thank my colleague Elizabeth for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.